Hi, I'm Tamara Monosoff, and I'm the founder of MomInvented.com and my new mentoring and training website, TamaraMonosoff.com. Thanks so much for joining us. And if you have a product idea that you're considering bringing to market, most likely one of the first questions that you have on your mind is, how can I protect it? And that's why I'm delighted to have our special guest and my friend, John Merchant of J. Merchant Law, join us today. John is a business law attorney as well as an intellectual property attorney. John, thank you so much for joining us.
It's great to be here. Thanks.
John, one question that is repeatedly asked of me, and so I'm so glad that you're here to answer this, is what is the difference between a utility patent and a design patent? And what level of protection do you get with either patent?
Well, the answer to most legal questions is it depends. But generally speaking, there are three types of patents. There are categories of patents. There are utility patents, design patents, and plant patents. But when it comes to products, most of the time you're talking about a utility patent, which has to do with a novel and not obvious functional difference between what you have in the prior art, and a design patent, which doesn't have to do with the function, it has to do with the aesthetics. And sometimes the two overlap. But
what do you mean? Wait, what do you mean by the aesthetics?
Well, the aesthetics, like a shape or like a shape of a lamp, or the shape of a particular a type of product that is not dictated by the function. In other words, if you took away that shape, the thing would still function as the product that you wanted, but there's something about the aesthetics that are particularly attractive to the marketplace. They're new, it's different and attractive, and those can be very powerful patents. Patents on, for example, the rabbit wine opener. Many of those are design patents, and there's nothing new about the function of the wine opener. A wine opener operates like many other wine openers that have come before it, but the novel design aspects are very powerful in the marketplace, and so protecting those with design patents has been very helpful and profitable for the company that owns the patent. So the difference between the two patents are utility patents have to do with the function of the product, and design has to do with the aesthetic shape of the shape or other aspects that are visual. Aspects of the product. Now, normally when people think of patents, they're thinking of utility patents. And the power of utility patents is, one, they have a longer term. In other words, the term of the patent is longer. It's usually in the neighborhood of 17, 18 years from the time it gets issued. Design patents have a shorter terms, 14 years. Utility patents are broader in scope generally because what they do is they apply to equivalent items that accomplish the same function. So you can have different embodiments of the same device or the same invention, and it still be covered under one patent. So, for example, if you had something that functioned a certain way and had a certain look, or had a certain aspects of it that are different than a very similarly functioning product, but that looks different or has some additional aspects to it, you could say, well, those are two embodiments of the same thing, and therefore they would be covered under this single patent. Design patents are more narrow. Design patents have been described in the past, they're not entirely accurately, as picture patents. So they go to exactly what is shown in a single embodiment of what you're patenting. It covers things that would be similar, that would be considered to be very, very similar, but the scope of it is narrower. So design patents are easier to get around than utility patents. One technique that people use is if they have different embodiments of something and it has to do with the design and not necessarily the function, they'll file multiple design patents. One of the advantages of a design patent is they're much, much less expensive to get than a utility patent. You know, a utility patent requires a lot of writing, requires a numerous illustrations of different embodiments. It requires a lot of formal technical legal work that goes into the back and forth between yourself and the inventor and the patent office to get the patent. Design patents basically are a set of drawings that pertain to one embodiment and not very much writing at all. So they're much less expensive to prepare, and the filing fees are a lot less. Also, utility patents, you have to pay what's called maintenance fees. Once you get the patent over a period of 3.5, 7.5, 11.5 years, if you want to keep the patent term going, you have to file maintenance fees, and those can be very expensive. Design patents don't have maintenance fees. So the other thing I want to mention with regards to the differences is sometimes a single product can be utility patent can be available and a design patent can be available. So you can sort of choose which one you want to go with, or you can file both simultaneously. So there are a lot of options, and each one should be considered carefully before you go ahead and start filing for patent.
John, thank you so much. That was really helpful in describing the differences between a utility patent and a design patent. So thanks so much for taking the time with us today.
I'm glad to be here.
I hope you'll join us for our next session with John, because John is going to explain something that I think is an incredibly useful tool, and it's called a provisional patent application. This thing is great. I've used it many, many times throughout my business, and John is going to explain in detail what it is and how it is useful for you, or how it may be useful for you. I hope you'll tune in with us next time. Thanks so much.